Dealing with a loved one's estate after they pass can feel overwhelming, especially when faced with the complexities of probate. But what if you had the information you needed to face it with clarity and confidence? Hey folks, and welcome to Everything Estate Planning, where our goal is to make the process of estate planning more straightforward and accessible for everyone. In today's video, we're going to explore the topic of probate, explaining what it is, when it's required, and how you can make the process easier for yourself and your loved ones. So go and grab a cup of tea, get comfortable, and let's explore probate together. Let's take a look at what we'll be covering in today's video. We're going to actually start by explaining what probate is and why it's important. Next, we're going to clarify when probate is required and actually when it might not be necessary. We're going to go over what it means to be an executor and the key responsibilities of that role. We'll discuss how long probate usually takes and what costs you should expect. Finally, we're going to explore how probate actually fits into your estate plan, sharing some practical tips to help make the process smoother and less stressful for everyone involved. As always, if you're looking for something specific, we've included timestamps to help you jump straight to any section you want to watch. So what exactly is probate? In straightforward terms, probate is the legal process of managing and distributing someone's estate after they pass away, including money, property, possessions. If there is a will, it must be proven and valid. Then the executors named in the will receive a grant of probate, giving them the authority to manage the estate. This step is essential as institutions like banks and the land registry require this grant to release funds or transfer property. If there is no will, an administrator is appointed instead and granted letters of administration. The estate's then distributed according to the rules of intestacy. Essentially, probate ensures the estate is properly managed with debts and taxes being paid and assets being distributed to beneficiaries. The process can take months, depending on the estate's size, complexity, and any potential disputes that may arise. Let's talk about when probate is needed. Probate is typically required when someone passes away and leaves behind assets solely in their name, such as property, bank accounts, or investments. So let's look at this in a bit more detail and go through some of the common situations where probate is actually required. Firstly, if the deceased owned property like a house or land in their name only, probate is usually required to sell or transfer the property. For bank accounts held solely in the deceased name, probate may be needed to release the funds, especially if the account balance exceeds the bank's threshold, which can typically range from £5,000 all the way up to £50,000. If the deceased owned investments, such as stocks and shares, probate is usually required before they can be sold or transferred. Finally, high-value estates, particularly those exceeding the inheritance tax threshold, almost always require probate. To clarify, let's take a look at some situations where probate is not required. If assets like property or bank accounts are jointly owned, they usually pass directly to the surviving owner without the need for probate. For low-value estates with minimal assets and no property, probate may not be necessary. Many banks release funds without probate if the total value is below their specific threshold. It's always important to check with the relevant banks to confirm their particular requirements. If you've been named as an executor in a will or appointed as an administrator by the courts, you are the person trusted with the responsibility of carrying out the final wishes of someone who's passed away. It's an honour to be chosen for the role, but it's also a significant and sometimes complex responsibility. It's important to be aware that an executor is legally responsible for carrying out the terms of the will and managing the estate in accordance with the law. Failure to fulfill these duties properly can result in personal liability for the executor. So what does being an executor really involve? Let's walk through some of the key duties in the order they need to be completed. First of all, before applying for probate, the executor must determine if inheritance tax is due and arrange for payment. Here's how to handle this particular step. Step 1. Value the estate. Gather information about the deceased assets and liabilities, including property, bank accounts, investments and debts. This valuation will determine if the estate exceeds that particular IHT threshold. Step 2 is complete inheritance tax forms. If no tax is due, submit the appropriate form for non-taxable estates. For taxable estates, submit the required form along with any supporting documents to provide detailed information about the assets in the estate to HMRC. These forms can be obtained from the government website. Step 3 is pay any outstanding IHT. If inheritance tax is due, some or all of it must be paid before applying for probate. Banks often release funds directly to HMRC for this purpose. Step 4 is obtain IHT reference. Acquire a reference from HMRC to confirm that IHT has been paid or accounted for, which is required for the probate application. Once inheritance tax has been addressed, the next major duty is applying for probate, which grants you the authority to manage the estate. Here's how. Step 1 is gather documents. You're going to need the original will, the death certificate, and proof of inheritance tax submission or payment. It's also advisable to obtain multiple certified copies of the death certificate for use with banks, insurance companies, and other institutions who may require a copy during the process. Step 2 is complete the probate application form. You can apply online through the government's probate service or use the form PA1P if there's a will, or PA1A if there is no will. Step 3 is you're going to need to pay the probate fees. Now these are going to vary on the estate size. Step 4 is submit that particular application. You're going to need to send the forms with the original will and death certificate via special recorded delivery to the probate registry. And processing usually takes 4 to 8 weeks. If you're unsure about any of these particular steps, consider consulting a professional solicitor or estate planner. There are government helplines that can also give you some guidance in this particular area. Once probate is granted, the executor can begin managing the deceased assets. Here's what to do. Step 1 is identify assets. Locate and document all estate assets such as bank accounts, property, investments, pensions and personal belongings. Step 2, you're going to need to value those assets. Obtain professional valuations for property and high value items. For bank accounts and investments, request balances as of date of death. Step 3 is manage those assets. You're going to have to close bank accounts, sell property if necessary, and consider opening an executor's account to consolidate funds during this particular process. Step 4, keep records. Maintain a detailed log of all asset transactions and any changes in value. Clear records are essential for transparency, resolving disputes and providing beneficiaries with an accurate account of the estate administration process. I know it's tempting, but please don't skip this step. After gathering assets, the executor must settle the deceased liabilities. Here's how. Step 1 is identify debts. Notify creditors, including utility providers, loan companies and credit card issuers, to obtain final statements. Step 2 is pay debts. Use estate funds to settle debts in priority order. Funeral expenses, taxes, excluding inheritance tax, that's already been dealt with. Secured debts like mortgages and unsecured debts like credit cards. Step 3 is file a final tax return. Submit the deceased personal income tax return for the tax year for their death. You may also need to address things like capital gains tax and stamp duty if certain assets were sold during the estate administration. Again, be sure to keep detailed records, so this ensures transparency and compliance. Once all debts and taxes are paid, the executor can distribute the remaining assets by doing the following. Step 1. Review the will. You're going to need to identify beneficiaries and their entitlements. If no will exists, you're going to need to follow the rules of intestacy. Step 2, you're going to need to contact those beneficiaries and notify them and provide details of what they're going to receive. Step 3 is transfer assets. Distribute funds, transfer property ownership, and ensure beneficiaries receive relevant documentation, for example, share certificates. Step 4 is you're going to need to prepare an estate account. Provide a detailed summary of the estate's assets, debts, and distributions to beneficiaries. Step 5 is distribute the inheritance. Once all steps are complete, distribute remaining assets according to the will or intestacy rules. For minors or vulnerable beneficiaries, manage their inheritance through trusts or legal guardians as outlined in the will. By following these steps and ensuring compliance with legal requirements, you can effectively fulfill your responsibility as an executor while safeguarding yourself from liability. Let's talk briefly about timelines. How long does probate take? The duration of the probate process can vary greatly, depending on the complexity of the estate. Here's a general overview. For a relatively simple estate, probate typically takes between 9 to 12 months from start to finish. If there are complicating factors such as disputes among beneficiaries, missing assets, or tax issues, the process can take much longer, sometimes even several years. A large part of the timeline depends on how quickly the executor can gather the necessary information and settle any outstanding matters. Seeking professional help can often speed up the process and avoid unnecessary delays. Now, let's break down the costs associated with probate in the United Kingdom. There are a few different costs you should be aware of. First off, we are in 2025, so these prices are relative to that particular time frame. In England and Wales, the probate application fee is currently £300 for estates valued over £5,000, and there is no fee for estates under this threshold. If you choose to hire a solicitor or estate planning professional, their fees typically vary depending on the complexity of the estate. Some professionals charge a fixed fee, while others charge a percentage of the estate value, which can range from 1% to 4%. Be sure to check these fees carefully. Other costs could include property valuations, inheritance tax payments, and settling any outstanding debts. Fortunately, these costs are usually covered by the estate, so executors don't need to pay out of their own personal pocket. However, it's important to factor in those expenses when calculating the overall value of the estate. Finally, let's talk about how probate fits into estate planning. Proactive estate planning can make the probate process much simpler for your loved ones. Here are some tips to keep in mind. The most important step is to create a clear, legally valid will. This helps to avoid disputes and ensures your wishes are carried out by a person of your choosing. Without a will, your estate is going to be subject to intestacy rules, which may not align with your intentions. If you would like to find out more about these rules, check out our video on Last Will and Testaments, a link to which is in the description below. Next, consider trust as another option for estate planning. Certain types of trust can help you avoid probate altogether, as assets held in trust don't form part of your estate and can be passed directly to beneficiaries. Again, we've got another video dedicated to the subject of trust, which you can also find below. Crucially, make sure all of your important documents like your will, property deeds, and insurance policies are organised and easily accessible. This will make the executor's job much easier. Finally, If your estate is likely to be over the inheritance tax threshold, consider speaking to a financial advisor or estate planner to explore ways to reduce the tax burden on your beneficiaries. Essentially, by planning ahead, you can reduce the complexity and stress of probate for your loved ones, ensuring that your wishes are fulfilled without unnecessary delays or costs. Navigating probate can be emotional and challenging, but it's essential for settling a loved one's final affairs properly. Understanding the process and responsibilities helps avoid complications and actually ensures informed decisions. If you are feeling overwhelmed, seek professional help. Solicitors or estate planning professionals can provide guidance, and they can prevent mistakes and ensure everything complies with the law. The goal here is to honour the wishes of the person who's passed away and manage their estate respectfully, making a tough time easier for everyone involved. Whether you're an executor handling probate or someone planning ahead for the future, Elm Legal Services is here to help. We offer professional probate and estate planning services tailored to your needs. So feel free to reach out to us for guidance or visit our website for more information and resources. We've even got a free webinar dedicated to assisting executors with probate, a link to which will be left in the description below. So thank you for spending some time with us today. And if you have any questions or thoughts, please share them in the comments below. Your feedback helps us improve and create more valuable content for a wider audience. So if you found the video helpful, please don't forget to give that like button a friendly handshake, subscribe and tap the notification bell. It doesn't cost you a penny and it means you won't miss any of our upcoming videos. Remember, a little planning today can make a big difference tomorrow. Until next time then, stay safe, stay informed and stay tuned.